afternoon, and welcome to the June 13th, 2022 No Surprises Act Qualifying Payment Amounts, or QPAs, Calculation Methodology webinar. My name is Isaac Holloway of Artix, and I will be your facilitator for today's call. Also with us today are subject matter experts from CMS who will be available to respond to your questions during today's session. Next slide, please. The agenda for today's session is as follows. We will begin with a few preliminaries, after which CMS will present on the qualifying payment amounts, or QPA overview, to include subjects such as the median contracted rate, same insurance market, same or similar item or service, provider in the same or similar specialty, facility of the same or similar facility type, geographic region, and other topics that you see displayed on your screen. We will then have a 15-minute Q&A session before discussing QPA audit authority, QPA audit scope, the QPA audit process to include documentation requests, civil money penalty authority, and then our final Q&A session, and then our closing remarks. This is a 120-minute webinar session. For questions regarding logistics and registration, please contact the registrar at 800-257-9520. On this slide, we would like to provide you with some webinar audio access tips. Please hardwire your computer as opposed to using the Wi-Fi. Close any unnecessary applications on your browser and browser sessions on your device for better connectivity. Reduce simultaneous streaming activities by others in your current workplace or home to increase your bandwidth. Disconnect from any virtual private networks for the best experience, and switch to phone if you lose web connectivity or sound when listening to your computer. We would also like to advise attendees that there is live closed captioning available. To turn on your closed captioning, please click the closed caption icon on your webinar screen. The information provided in this presentation is intended only to be a general informal summary of technical legal standards. It is not intended to take the place of these statutes, regulations, or formal policy guidance upon which it is based. This presentation summarizes current policy and operations as of the date it was presented. We encourage readers to refer to the applicable statutes or regulations and other interpretive materials for complete and current information. The contents of this document do not have the force and effect of law and are not meant to bind the public in any way, unless specifically incorporated into a contract. This document is intended only to provide clarity to the public regarding existing requirements under the law. This communication was printed, published, or produced and disseminated at U.S. taxpayer expense. Now that we have concluded our introduction to today's event, I will turn the session over to Colin of CMS to begin our presentation. Colin?
Hi there, everyone. My name is Colin Goldfinch. I recently joined the team here at CSIO at CMS to help coordinate No Surprises Act implementation. I'm going to turn it over to the subject matter experts in just a second, but I just wanted to take a second to introduce myself and kick things off. As I'm sure you all know, implementing the No Surprises Act is a top priority here, and of course, it's an expansive law. So that means that there's a lot of ongoing work to keep improving things and to keep, improving implementation. And of course, that means that there's a lot of work for payers and providers to continue to learn about the law's new requirements and just generally get up to speed. So, as I'm sure you all know, and I'm sure it's the reason you're here, the qualifying payment amount it's a critical part of making the law work. So we're really glad to have the time to speak with you about it today and go through the particulars and just generally, want you to know that we want to have open lines of communication with you because it's so important to get this right. So thank you, and I'll turn it over to the subject matter experts.
Thanks, Colin. Good afternoon, everyone. My name is Geraldine Detzer, and I'm a member of the oversight group at CSIO here in CMS. We really appreciate your taking the time to join us for today's training. I am going to be focusing primarily on information related to the QPA calculation methodology that is set out in the July 2021 interim final rules. This part of the presentation walks through the methodology for calculating the QPA. The presentation will then discuss the alternative methodology for determining the QPA in cases where a plan or issuer has insufficient information to calculate a median contracted rate for an item or service using contracted rates as of January 31st, 2019. This overview slide is really intended to provide some introductory context for why the QPA is important and how it is applied. The QPA is the basis for determining individual cost sharing for items and services covered by the balanced billing protections in the No Surprises Act under certain circumstances. Cost sharing for emergency items and services and non-emergency items and services when furnished by an out-of-network provider in an in-network facility must be based on the lesser of billed charges or the QPA, unless an all-payer model agreement or a specified state law applies. And for purposes of this presentation, we will assume that an all-payer model agreement nor a specified state law is applicable. Additionally, cost sharing for air ambulance services must always be based on the lesser of billed charges or the QPA. In addition to forming the basis for those cost sharing items, certified independent dispute resolution or IDR entities are required to consider the QPA when selecting between the offer submitted by a plan or issuer and the offer submitted by a facility or provider of air ambulance services when determining the total out-of-network payment rate for items and services subject to the federal IDR process. Next slide. The QPA for a given item or service is generally the median contracted rate on January 31st, 2019 for the same or similar item or service increased for inflation. This definition outlines the basic steps for determining the QPA. Step 1 is to determine the median contracted rate for the item or service, and step 2 is to follow the process to increase that median contracted rate for inflation. Next slide. The median contracted rate for an item or service is determined by identifying the contracted rates of all plans of the plan sponsor or administering entity if applicable, or all coverage offered by the issuer in the same insurance market for the same or similar item or service that is provided by a provider in the same or similar specialty or facility of the same or similar facility type and provided in the geographic region in which the item or service is furnished. And then arranging the contracted rates from least to greatest and selecting the middle number, or if there's an even number of contracted rates, the average of the two middle numbers. Through rulemaking, CMS has established the methodology that plans and issuers must use to calculate the median contracted rates, and the NSA and the interim final rules from July 2021 assign a specific meaning to each of the bolded terms that you see on this slide. I'm going to be discussing each of those terms in greater detail for much of the rest of my time with you this afternoon. Next slide. So we'll start with contracted rates. A contracted rate is the total amount, including cost sharing, that a group health plan or health insurance issuer has contractually agreed to pay a participating provider, facility, or provider of air ambulance services for covered items and services, whether directly or indirectly, including through a third-party administrator or pharmacy benefit manager. I will note that where a plan or issuer rents a provider network or otherwise contracts with a third party to manage its provider network, contracted rates between providers and the entity responsible for managing the provider network on the plan or issuer's behalf are treated as the plans or issuer's contracted rates for purposes of calculating the QPA. Next slide. Specific rules determine how and whether a contracted rate is included or excluded for purposes of determining the median contracted rate. The amount negotiated under each contract is treated as a separate amount. The definition of contracted rate for purposes of calculating the median contracted rate excludes rates paid under single case agreements, letters of agreement or similar arrangements between a provider, facility, or provider of air ambulance services and a plan or issuer when used to supplement the network of the plan for a specific enrollee, participant, or beneficiary in unique circumstances. The rate negotiated under a contract constitutes a single contracted rate, regardless of the number of claims paid at that contracted rate. Next slide. CMS has also established certain guidelines to be followed when determining the median contracted rate. So if a plan or issuer has separate contracts with individual providers, the rate under each contract constitutes a single contracted rate, even if the same rate is paid to other providers under separate contracts. A single contract with a provider group or facility with the same negotiated rate applying to all providers in the group or facility. In that case, the rate negotiated with that provider group or facility is treated as a single contracted rate. However, if a plan or issuer has a single contract with multiple providers with separate negotiated rates with each particular provider, then each unique contracted rate constitutes a single contracted rate for purposes of determining the median contracted rate. Next slide. The next one of those bolded terms we're going to address is same insurance market. Insurance market is defined as the individual market, which excludes short-term limited duration insurance, the small group market, and the large group market. And the definitions for each of those terms, individual market, small group market, and large group market, are defined by the Public Health Services Act. For self-insured group health plans, insurance market means all self-insured group health plans, other than account-based plans and plans that consist solely of accepted benefits of the plan sponsor, or at the option of the plan sponsor, all self-insured group health plans administered by the same entity, which includes a TPA contracted by the plan that is responsible for calculating the QPA on behalf of the plan. Any plan or coverage that is not a group health plan or group or individual health insurance coverage offered by a health insurance issuer, as those terms are defined in the statutes, such as a Medicare Advantage or Medicaid Managed Care organization plan, must not be included in any insurance market for purposes of determining the QPA. I'll note that the relevant market is determined irrespective of the state, and all markets exclude coverage that consists solely of accepted benefits. Next slide. The median contracted rate is determined based on contracted rates for the same or similar item or service. This is defined as a healthcare item or service billed under the same service code or a comparable code under a different procedural code system. Service codes are the codes that describe an item or service and can include current procedural terminology or CPT codes, healthcare common procedure coding system or HCPCS codes, or diagnosis related group or DRG codes. Next slide. With respect to modifiers, which are defined as codes that are applied to the service code to provide a more specific description of the furnished item or service, and that may adjust the payment rate or affect the processing or payment of the code billed. If application of a modifier causes contracted rates to vary, the plan or issuer must calculate a separate median contracted rate for each such service code modifier combination. However, modifiers that don't cause contracted rates to vary must not be taken into account when calculating the median contracted rate. Additionally, we note that median contracted rates must be calculated separately for CPT code modifiers that distinguish the professional and technical services component. Next slide. Median contracted rates are based on items or services provided by providers in the same or similar specialty. This is defined as the practice specialty of a provider as identified by the plan or issuer consistent with the plan's or issuer's usual business practice. If a plan or issuer has contracted rates for a service code that vary based on provider specialty, the median contracted rate must be calculated separately for each provider specialty. With respect to air ambulance services in particular, all providers of air ambulance services are considered to be a single provider specialty. Next slide. Similarly, the median contracted rate is based on items or services furnished in a facility of the same or similar facility type. This is defined to mean with respect to emergency services, either an emergency department of a hospital or an independent freestanding emergency department. If a plan's or issuer's contracted rates for emergency services vary based on the type of facility, that is, whether a facility is a hospital ED or an independent freestanding ED, the median contracted rate is calculated separately for each of those facility types. We note that plans and issuers may not separately calculate a median contracted rate based on other characteristics of facilities that might cause contracted rates to vary, such as whether a hospital is an academic medical center or a teaching hospital. Next slide. Median contracted rate is also based on items and services furnished in the same geographic region. Different geographic regions apply with respect to air ambulance services and all other items and services covered by the balanced billing protections on the No Surprises Act other than air ambulance services. For non-air ambulance items and services, the primary definition is one region for each metropolitan statistical area or MSA in the state, and one region consisting of all other portions of the state. If a plan or issuer does not have sufficient information to calculate a median contracted rate for the geographic region under the primary definition, geographic regions must be defined according to the first alternative definition. For non-air ambulance items and services, that first alternative definition is one region consisting of all MSAs in the state and one region consisting of all other portions of the state. For these non-air ambulance items and services, if a plan or issuer still does not have sufficient information after applying the broader first alternative definition, then the geographic region must be defined using the second alternative definition, which is one region consisting of all metropolitan statistical areas in the census division and one region consisting of all other portions of the census division. For air ambulance items and services, the primary definition is one region consisting of all MSAs in the state and one region consisting of all other portions of the state. For air ambulance services, there is one alternative definition that must be used if a plan or issuer does not have sufficient information to calculate the median contracted rate for the geographic regions under the primary definition. And that alternative definition is one region consisting of all metropolitan statistical areas in the census division and one region consisting of all other portions of the census division. Next slide. We note that MSAs, or metropolitan statistical areas that cross state boundaries, are divided between the respective states, with all counties in a particular MSA in each state counted as a geographic region. Additionally, the geographic region to be applied for air ambulance services is determined by the point of pickup, which is the location of the individual at the time the individual is placed on board the air ambulance. Next slide. The QPA methodology in the July 2021 interim final rules establishes an approach for calculating a median contracted rate where payment for an item or service is not fully on a fee-for-service basis. For example, under bundled and fully or partially capitated arrangements. The interim final rules give as examples bundled payment arrangements under which plans and issuers may reimburse a provider for multiple items and services under a single billing code, and capitation arrangements under which a provider or panel of providers is paid a fixed amount per member per month. In general, the plan or issuer must calculate a median contracted rate for each item or service using the underlying fee schedule rates for the relevant items and services if those are available. The underlying fee schedule rate is defined as the rate for a covered item or service that a group health plan or health insurance issuer uses to determine an individual's cost-sharing liability for the item or service when that rate is different from the contracted rate. If there is no underlying fee schedule rate, the plan or issuer must calculate the median contracted rate using a derived amount, which is the price that a plan or issuer assigns an item or service for purpose of internal accounting, reconciliation with providers, or for the purpose of submitting data in accordance with 45 CFR 153.710C. When calculating median contracted rates, plans and issuers must exclude risk sharing, bonus, penalty, and other incentive-based and retrospective payments or payment adjustments. Next slide. The next several slides move on from the definition of median contracted rate and those bolded terms I highlighted earlier to the second major step involved in calculating the QPA, which is indexing a median contracted rate to account for inflation. In cases where the median contracted rate is determined using January 31st, 2019 contracted rates, to calculate the QPA for items and services furnished during 2022, the planner issuer must increase the median contracted rate as of January 31st, 2019 by the percentage increase in the Consumer Price Index for all urban consumers, or CPIU, over 2019, the percentage increase over 2020, and the percentage increase over 2021. To calculate the QPA for items and services furnished during 2023 or a subsequent year, the QPA for 2022 is then adjusted annually by the annual increase in the CPIU. Plans and issuers will calculate the increases using the factors determined by the Treasury Department and the IRS and published in guidance by the IRS. The percentage increase for any year is calculated by using the CPIU published by the Bureau of Labor Statistics at the Department of Labor. We'll note that for this purpose, the CPIU for each calendar year is the average of the CPIU as of the close of the 12-month period ending on August 31st of the calendar year, rounded to 10 decimal places. Next slide. Special rules apply when calculating the QPA for items or services for which a plan or issuer generally determines the reimbursement level for the same or similar items or services by multiplying the contracted rate by another unit, such as time or mileage. The rule for the QPA for unit-based items and services is that such QPA is calculated by determining the median contracted rate for the item or service, indexing that median amount in accordance with the otherwise applicable rules regarding indexing, and then applying the pertinent multipliers. Next slide. For anesthesia services furnished during 2022, the QPA is calculated by taking the median contracted rate for the anesthesia conversion factor, which is determined in accordance with the methodology for calculating median contracted rates for service code modifier combinations, for the same or similar item or service as of January 31st, 2019, and increasing that amount to account for changes in the CPIU. That amount is referred to as the indexed median contracted rate, and it is then multiplied by the sum of the following three factors: the base unit for the anesthesia code, the base unit for the anesthesia service code, the time unit, and the physical status modifier unit to calculate the QPA. For anesthesia services furnished during 2023 or a subsequent year, the QPA is calculated by taking the indexed median contracted rate for anesthesia conversion factor and adjusting that amount by the percentage increase in the CPIU over the previous year. The indexed median contracted rate is then multiplied by the sum of those three factors: the base unit for the anesthesia service code, the time unit, and the physical status modifier units for the participant, beneficiary, or enrollee to calculate the QPA. Next slide. For air ambulance services, payers often reimburse air ambulance services in part by using air mileage service codes and reimbursement levels that reflect the number of miles an individual is transported by the air ambulance, which are referred to as loaded miles. Payment amounts are calculated by multiplying the negotiated rate for the service code, or the air mileage rate, by the number of loaded miles. The QPA for air ambulance services billed using the air mileage service codes that are furnished during 2022 is calculated by first increasing the median contracted rate to account for changes in the CPIU. This amount is referred to as the indexed median air mileage rate, and then multiplying the indexed median air mileage rate by the number of loaded miles. For air ambulance services that are furnished during 2023 or a subsequent year using the service codes on the slide, the QPA is calculated by increasing the index median air mileage rate determined for such services furnished in the preceding year, and then multiplying that index median air mileage rate by the number of loaded miles. Next slide. The next section of the presentation will focus on how to calculate the QPA when a plan or issuer cannot identify the median contracted rate using the standard methodology. This could arise in a number of circumstances. An alternative process is therefore used to determine the QPA in cases where a group health plan or health insurance issuer lacks sufficient information to calculate the median of contracted rates in 2019, as well as for newly covered items and services in the first coverage year after 2019. In cases in which a plan or issuer does not have sufficient information to calculate a median contracted rate, the plan or issuer must determine the QPA using an eligible database, which we'll discuss in a few slides. Next slide. First, we'll discuss what we mean by sufficient information. A plan or issuer has sufficient information to calculate the median of contracted rates for an item or service if the plan or issuer has at least 3 contracted rates on January 31st, 2019. Where a plan or issuer does not have sufficient information under that definition to calculate the median contracted rate based on January 31st, 2019 contracted rates, but later gains sufficient information, the plan or issuer must calculate the QPA using the median contracted rate for the first sufficient information year. Next slide. The term first sufficient information year means something different in each of the 2 contexts in which it might have relevance for determining the QPA of an item or service. First, it is defined in the case of an item or service for which a plan or issuer does not have sufficient information to calculate the median of contracted rates in 2019. It is the first year after 2022 for which the plan or issuer has sufficient information to calculate the median of contracted rates in the year immediately preceding that first year after 2022. In the case of a newly covered item or service, it is the first year after the first coverage year for such item or service for which the plan or issuer has sufficient information to calculate the median of the contracted rates in the year immediately preceding that first year. Next slide. In cases where contracted rates for a year after 2019 must be used to calculate the median contract rate, a plan or issuer will be considered to have sufficient information to calculate the median contracted rate for a year if both of the following conditions are met. First, the plan or issuer has at least 3 contracted rates on January 31st of the year immediately preceding that year, and the contracted rates account or are reasonably expected to account for at least 25% of the total number of claims paid for the item or service for that year, with respect to all plans of the sponsor or, if applicable, the administering entity, or all coverage offered by the issuer in the same insurance market. I'll note that the requirement that a plan or issuer have at least 3 contracted rates for a particular item or service in a geographic region is the same as the requirement that applies when determining whether there is sufficient information to calculate a median contracted rate for items and services furnished during 2022 using the January 31st, 2019 median contracted rates. However, the 25% minimum claims volume requirement applies only where contracted rates for years after 2019 are used to determine whether a plan or issuer has sufficient information to calculate the median contracted rate in the first sufficient information year. Next slide. Where a plan or issuer does not have sufficient information to calculate a median contracted rate, the plan or issuer must determine the QPA using an eligible database. A third-party database may be an eligible database if it satisfies all of the following conditions. It has no conflicts of interest. It has sufficient information regarding in-network allowed amounts paid to healthcare providers or facilities for relevant items and services furnished in the applicable geographic region. And it has the ability to distinguish amounts paid to participating providers and facilities by commercial payers from all other claims data. State all-payer claims databases have been deemed categorically eligible. Next slide. As noted in the previous slide, an eligible database is required to be free from any conflicts of interest. Specifically, the database or the organization maintaining the database cannot be affiliated with, owned or controlled by any health insurance issuer or a healthcare provider, facility, or provider of air ambulance services, or any member of the same controlled group as or under common control with any such entity. For purposes of applying the controlled group rules to eligible databases, a controlled group means a group of 2 or more persons that is treated as a single employer under the IRS code sections on this slide. I'll note that the July 2021 interim final rules preamble includes examples of conflicts of interest. Next slide. To calculate the QPA for an item or service furnished during 2022, or for newly covered items or services in the first coverage year using an eligible database, a plan or issuer must first identify the rate in the database that is equal to the median of the in-network allowed amounts for the same or similar item or service in the geographic region in the year immediately preceding the year in which the item or service is furnished, or for a newly covered item or service, the year immediately preceding the first coverage year. Then increase the median in-network allowed amount by the percentage increase in the CPIU over the preceding year. For each subsequent year before the first sufficient information year, the plan or issuer must increase the QPA applicable in the immediately preceding year by the percentage increase in the CPIU over the preceding year. Next slide. A plan or issuer that uses a database to determine the QPA for an item or service must use the same database to determine the QPA for that item or service through the last day of the calendar year. If a different database is selected for some items or services, the basis for that selection must be one or more factors not directly related to the rate of those items and services. For example, the sufficiency of data for those items and services. Additionally, plans and issuers are responsible for the costs associated with using an eligible database to determine the QPA. Next slide. In cases where a sponsor of a group health plan or health insurance issuer is newly offering a plan or coverage in a geographic region in a year after 2019, if the plan or issuer otherwise has sufficient information to calculate a median contracted rate in 2019 in the geographic region where the item or service is furnished. So for example, where the sponsor or issuer has sufficient existing provider contracts under other current coverage in that geographic region, the QPA is determined using the standard methodology. However, if the plan or issuer does not have sufficient information to calculate a median contracted rate in 2019 in the geographic region, so where the sponsor or issuer did not offer any plan or coverage in 2019, for items and services in the first year in which the plan or coverage is offered in the geographic region, the QPA is determined according to the rules that generally apply when there's insufficient information, including the use of an eligible database. I'll note that new plans and coverage that initially do not have sufficient information to calculate a median contracted rate must use a QPA based on information for the first year of coverage from an eligible database indefinitely, updated only by the inflation adjustment. To calculate the QPA for items and services furnished in a subsequent year, the plan or issuer must increase the QPA for items or services furnished in the immediately preceding year by the percentage increase in the CPIU over the previous year. Next slide. Regarding new service codes, which are defined as a service code that was created or substantially revised in a year after 2019, in situations in which a plan or issuer is billed for a covered item or service using a new service code, the plan or issuer must determine the QPA using the following steps. Step 1, the plan or issuer must identify a reasonably related service code that existed in the immediately preceding year. So for example, another service code in the same family of codes, or a code for services that represent similar relative valued units. Next slide. Then step 2, calculate the applicable relativity ratio. If the Medicare program has established a payment rate for an item or service billed under the new service code, the plan or issuer must calculate the ratio of the Medicare payment rate for the item or service billed under the new service code compared to the Medicare payment rate for the item or service under the related service code, with both rates disregarding adjustments for value-based purchasing. However, if the Medicare program has not established a payment rate for an item or service billed under the new service code, the plan or issuer must calculate the ratio of the rate that the plan or issuer pays for an item or service billed under the new service code compared to the rate that the plan or issuer pays for an item or service under the related service code. Step 3, the plan or issuer should multiply the ratio in step 2 by the QPA for the related service code for the year in which the item or service is furnished. Next slide. That last slide concludes the main portion of the presentation that focused on QPA calculation methodology. But before we pause for Q&A, I'm going to spend a few minutes reviewing the information that plans and issuers must disclose with any initial payment or notice of denial of payment for items and services that are subject to the NSA's cost sharing and balance billing requirements. This slide covers the items that must be included on all initial payments and notices of denial, regardless of requests. So the July 2021 interim final rules require that plans and issuers make certain disclosures with each initial payment or notice of denial of payment, and that plans and issuers must provide additional information upon request of the provider, facility, or provider of air ambulance services. First, a plan or issuer must provide the QPA for each item or service involved, and we encourage plans and issuers to provide the QPA as clearly and unambiguously as possible. Second, a plan or issuer must provide a statement certifying first that the QPA applies for purposes of the recognized amount, or in the case of air ambulance services, for calculating individual cost sharing. And second, that each QPA shared with the provider, facility, or provider of air ambulance services was determined in compliance with the methodology outlined in the July 2021 interim final rules. Third, a plan or issuer must provide a statement informing the provider, facility, or provider of air ambulance services that they may initiate the 30-day open negotiation period. And if that fails to produce a determination, they may then initiate the federal IDR process within 4 days of the end of open negotiations. And fourth and finally, the plan or issuer must also provide contact information for the appropriate office or person to initiate open negotiations. Next slide. In a timely manner, at the request of the provider, facility, or provider of air ambulance services, a plan or issuer must provide the following in addition to the elements we discussed on the last slide. Information about whether the QPA includes contracted rates that were not set on a fee-for-service basis for the specific items and services at issue, and whether the QPA was determined using underlying fee schedule rates or a derived amount. If an eligible database was used to determine the QPA, information to identify which database was used to determine the QPA. If a related service code was used to determine the QPA for a new service code, information to identify which related service code was used. And if applicable, a statement that the plans or issuers' contracted rates include risk sharing, bonus, penalty, or other incentive-based or retrospective payments or payment adjustments that were excluded to calculate the QPA. Next slide. This slide provides an overview of some key terms, which we hope will be a useful ongoing reference when the slides are posted online. But this also concludes the presentation on QPA calculation methodology.
I will now turn it over to Hussein Zaid to continue with our QPA audit authority.
Thank you, Isaac, and thank you, everyone. So my name is Hussein Ziad, and I am a health insurance specialist at the Compliance and Enforcement Division in the Oversight Group, and I will be presenting the QPA audit section. Title 42 of the U.S. Code 300GG-111A2 gives us that authority to conduct these audits. In general, no later than October 1st, 2021, the Secretary, in consultation with the Secretary of Labor and the Secretary of the Treasury, shall establish through rulemaking a process in accordance with Clause II under which group health plans and health insurance issuers offering group or individual health insurance coverage are audited by the Secretary or applicable state authority to ensure that such plans and coverage are in compliance with the requirement of applying a qualifying payment under this section, and such qualifying payment amount so applied satisfies the definition under paragraph 3E with respect to the year involved, including with respect to a group health plan or health insurance issuer described in clause 2 of such paragraph 3E. Next slide. Under this process established pursuant to Clause I, the Secretary shall conduct audit described in such clause with respect to year beginning 2022 of a sample to such a year of claims data from not more than 25 group health plans and health insurance issuers offering group or individual health insurance coverage, and may audit any group health plan or health insurance issuer offering group or individual health insurance coverage if the Secretary has received any complaint or other information about such plan or coverage respectively that involves the compliance of the plan coverage respectively with either the requirements described in subclause 1 and 2 of such clause. Please note that state regulators enforcing the qualifying payment amount provisions may call QPA audits of plans and issuers within their jurisdiction. Plans and issuers should check with such enforcing states regarding their process. Next slide. The implementing regulation is 45 CFR subsection 149-140F. The procedures described in Part 140 of this subchapter apply with respect to ensuring that a plan or coverage is in compliance with the requirement of applying a qualifying payment amount under the subpart and ensuring that such amount so applied satisfies the requirements under the section regarding QPA methodology as applicable. Next slide. The audit's scope is applicable to services and items covered by group health plans or health insurance issuers offering group or individual health insurance coverage, but does not include short-term, limited duration insurance, health reimbursement arrangements, and other account-based plans or accepted benefit insurance plans. A call letter will be sent notifying the plan sponsor or issuer that a QPA audit has commenced and requesting the initial audit and data and documents. A pre-examination meeting will be conducted to go over the data and documents requested, set expectations for the audit, arrange and security access or training required if examiners are to access systems directly, and to answer questions from the plan or issuer. Next slide. Samples will be selected and additional documents will be requested and reviewed for those samples from the plan or issuer. The documents include claims-related items, information about the QPA sent with initial payments or notice of denial of payment, and other demonstrating regulatory compliance. Questions to the plan or issuer will be sent through a request for information, we call it RFIs, throughout the audit process. Preliminary findings of potential violations will be provided to the plan sponsor or issuer through a criticism prior to the draft final report. The plan sponsor or issuer will have an opportunity to provide additional information if they disagree with the preliminary findings. Next slide. QPA data and document requests. A comprehensive list of all insurance market as defined in 45 CFR 149.148.8, in which the plan or issuer offers coverage and each plan offered in such market. For each plan on the list, provide documents related to each plan's coverage and benefits, which includes but is not limited to the policy certificate or contract insurance and schedule of benefits. Include a narrative describing the plans or issuer's QPA calculation methodology demonstrating compliance. The narrative should be in a step-by-step format and should be supplemented with any supporting documentation that is necessary to provide a clear and comprehensive explanation. This includes any QPAs of which the plan sponsor or issuer had insufficient information to calculate the median of contracted rates for items and services furnished in 2022. A read-only access, remote access, or other reasonable substitutes to the claims administration system applicable during the audit period that provides access to claims for which the requirement to a QPA applies. If unable to provide such access, please provide a claim data file in the format prescribed in the spreadsheet that will be provided with the call letter that includes all paid, denied, and pending claims for which the requirement to apply a QPA applies. And appeals of adverse benefit determinations for all such claims for all applicable plans effective during the audit period. One last point, previous slide. Also include a completed data file in the format prescribed in the spreadsheet that will be provided with the call letter that includes all QPAs calculated, whether or not associated with a claim during the audit period. Maybe I lost it. Thank you, Isaac. Provide claims handling manuals, internal bulletins, medical criteria used, and guidelines. The plan or issuer utilized at any point during the audit period that address how the plan identifies claims for which the requirement apply a QPA applies, and the plan and issuer applies the QPA to such claims. A complete complaint log or a similar documentation that identifies any entries with respect to QPAs as well as corresponding complaint file. And finally, for the QPA audit process, a draft final report will be provided to the plan sponsor or issuer once our review is complete and all criticisms have been responded to by the plan sponsor or issuer. The plan sponsor or issuer will have 30 calendar days from the date of receipt of the final report to either concur with the CMS position or positions as outlined in the report, explaining the plan of correction to be implemented, or dispute CMS's position or positions, clearly outlining the basis for its dispute and submitting illustrative examples where appropriate. Next slide. CMS will provide a response to each examination issue in its final report. CMS's reply will consist of one of the following: a concurrence with the issuers or plans, approval of the issuer or plan's proposed plan of correction, conditional approval of the issuers or plan's proposed plan of correction, which will include any modification CMS requires. Notice to the issuer or plan that there exists a potential violation of PHS Act requirements. Next slide. Civil Money Penalty Authority. 42 U.S.C. U.S. Code, subsection 300GG 22B2 gives statutory authority to impose civil monetary penalties. In general, subject to succeeding provisions of the subsection, any non-federal governmental plan that is a group health plan and any health insurance issuer that fails to meet a provision of this part or Part D applicable to such plan or issuer is subject to a civil money penalty under this subsection. Liability of penalty in this case of a failure by a health insurance issuer, the issuer is liable for such penalty, or a group health plan that is non-federal government plan, which is one sponsored by two or more employers, the plan is liable for such penalty, or not so sponsored, the employer is liable for such penalty. Next slide. Regulation implementing civil money penalty authority of violations of provisions under PHS Act, Part D 45 CFR. CFR 150.315, civil money penalty for each violation of 42 U.S. Code 300GG may not exceed $100 as adjusted annually for each day. For each responsible entity, for each individual affected by the violation, penalties imposed under this part are in addition to any other penalties prescribed or allowed by law. CFR 150.317 to 323 provide the factors used to determine the civil money penalty, including mitigating circumstances, aggravating circumstances, and any other matters of justice to be considered in setting the civil money penalty. Next slide. 150.341 state the circumstances under which a civil money penalty is not imposed. CMS does not impose any civil money penalties on any failure for the period of time during which none of the responsible entities knew or exercising reasonable diligence would have known of the failure. CMS also does not impose a civil money penalty for the period of time after any of the responsible entities knew or exercising reasonable diligence would have known of the failure if the failure was due to reasonable cause and not due to willful neglect, and the failure was corrected within 30 days of the first day that any of the entities against whom the penalty would be imposed knew or exercising reasonable diligence would have known that the failure existed. The burden is on the responsible party or entities to establish to CMS's satisfaction that no responsible entity knew or exercising reasonable diligence would have known that the failure existed. Next slide. CFR 150.343 to 347 requires CMS to send a notice of penalty to the responsible party with specific information that provides a right to the responsible party to initiate an appeal of civil money penalty under 45 CFR 150.401 and sets out how CMS may proceed if the responsible party does not submit an appeal within 30 days of the issuance of the notice of civil money penalty. Next slide. Civil money penalty process. CMS will go through the process of determining whether a civil money penalty is to be assessed if a violation is found during a QPA audit. The civil money penalty will be determined based on the factors permitted for consideration, including mitigating and aggravating circumstances and other matters as justice may require. A notice of civil money penalty will be sent to the responsible party. That party will have the right to appeal. If the appeal is not received within 30 days of the notice to the responsible party, CMS will send a notice to the responsible party with the final civil money penalty determination and how the plan sponsor, employer, or issuer can satisfy the judgment. Next slide, please. Contracts regarding QPA audits. CMS currently contracts with Examination Resource to assist with conducting the QPA audits. You will receive information on how to contact Examination Resource in the QPA audit call letter.
Immediately following this session, you will be automatically directed to the webinar survey. CMS encourages you to submit any ideas, suggestions, or feedback that you have regarding this webinar series. This concludes the June 13th, 2022 No Surprises Act Qualifying Payment Amounts Calculation Methodology webinar. Thank you all for joining us today. Stay safe and have a wonderful day.